Welcome to This Week in Education Law School Administrator's Guide, episode number 2. Each week, I share up-to-date court decisions on education law. I pay special attention to the decisions and arguments related to school administrators' daily work. Today, I focus on a case about school district's social media practice. The questions are: can a school district block its critics on the district's official Facebook page? Can school administrators personally block critics on their own social media accounts? In September 2020, a parent whose son has special needs posted comments on the school district's official Facebook page concerning the school's reopening, COVID-19 masking policies, disability rights, and child abuse. The school district deleted the parent's comments and blocked her ability to make further comments. Specifically, the parent alleged that the school district's head of communications was responsible for deleting her comments and blocking her from the Facebook page. The head of communications allegedly using a fake Facebook username to send a private message to the parent stating, "We have decided to ban you from the school district's Facebook page for continued violations of our terms and conditions." The parent filed a lawsuit claiming that the school district's social media accounts were public forums and the school district engaged in unconstitutional viewpoint discrimination by deleting her comments and blocking her from the public forums. Can a school district block its critics on its official Facebook page? Put differently, does a school district violate its critics' First Amendment right by blocking them on the district's official Facebook page? To answer this question, courts engaged in a 3-step analysis by asking 3 questions. First, whether the speech at issue is protected by the First Amendment. Second, whether the putative forum is susceptible to forum analysis at all. Third, whether the extent to which the government has controlled access is permissible given the type of forum at issue. Let's answer these 3 questions one by one. First, whether the speech is protected by the First Amendment. In this case, the speech at issue was the parent's Facebook comments about the school district's COVID policies and protocols. The parent's Facebook comments were the speech on matters of public concern, which falls squarely within the scope of the First Amendment protection. And there was no allegation that the parent's online criticism contained vulgar, obscene, threatening, or otherwise legally objectionable content, pushing it outside the realm of protected speech. The school district argued that the parent's allegations was too vague, and the parent did not identify what comments or statements were made, blocked, or deleted. The court noted that as long as the parents can describe in detail the nature and content of the comments that she posted, it is not required for purposes of pleading a First Amendment claim to provide a verbatim or hard copy record of her comments on social media. Second, whether the putative forum is susceptible to forum analysis at all. There are different types of forums: public forum, limited public forum, and non-public forum. The type of a forum is important in determining whether the speech and expression can be restricted. If the expression is in public forum, such as streets and parks, the government cannot restrict it. If the expression is in a limited public forum, for example, a student activity program held after school on school property and sidewalk on university campus that are not intended as an area for public expression, then the expression can be restricted if the expression is not consistent with the purpose of the forum. If the expression is in a non-public forum, for example, the property for which the government acts as proprietor, managing its internal operations, then restriction can be imposed. What type of forum is a school district's official Facebook page? Is it a public forum, limited public forum, or a non-public forum? A school district's official Facebook page is an arm of the government entity itself. In this case, the school district's official Facebook page was registered as a government organization and continued to hold itself out as a platform for unlimited and unrestricted discussion on matters related to school operations. So the school district's Facebook page was a public forum. Third, whether the extent to which the government has controlled access is permissible given the type of forum at issue. To decide whether the government has engaged in viewpoint discrimination, it is unnecessary to analyze whether the government's conduct was permissible based on the type of forum at issue. Viewpoint discrimination, which targets the specific views or opinions of the speaker rather than the subject matter generally, is prohibited in all forums. In this case, after the parent posted Facebook comments criticizing the school district's reopening plans and mask mandates, the head of communications deleted those comments and later used a different Facebook account to inform the parent that she would be blocked from the school district's Facebook page entirely. These allegations strongly support the inference that the school district took these actions because they did not like what the parent had said about their policies, or put it in First Amendment terms, because they were impermissibly motivated by a desire to suppress a particular point of view. The parents' Facebook comments satisfied all three steps of the analysis. The United States District Court held that the school district violated the parents' First Amendment right. In this case, the superintendent and assistant superintendent blocked the same parent on their Twitter accounts after the parent filed the lawsuit. Did they violate the parent's First Amendment right? The school district argued that the superintendent and the assistant superintendent were not acting in their official duty when they blocked the parent on Twitter. This argument was strikingly similar to a 2019 case in which former President Trump blocked his critics on Twitter. In that case, a group of Twitter users represented by the Ninth First Amendment Institute at Columbia University sued former President Trump for unlawful viewpoint discrimination after Trump blocked them from his Twitter account. The court noted that although the Trump's Twitter account, which Trump activated in 2009, almost 8 years before he assumed office, was initially private, the public presentation of the account after he became president bore all the trappings of an official state-run account. For example, the president and members of his administration regularly described the account as official, and the president regularly utilized the account as one of the main vehicles for conducting official business. The court rejected the Trump's contention that at the time he blocked the Twitter users from his Twitter account, he was exercising control over a private personal account, or stated differently, that he was not acting in his official duty. The court concluded that the account itself, at least after his inauguration in 2017, was presented as belonging to the President of the United States, and that he and others used the account on a regular basis to communicate with the public about the administration, including administration policy and personnel changes. The president's Twitter account had an interactive feature open to the public, making public interaction a prominent feature of the account. This unique characteristics transformed what would otherwise be a private social media platform into a public forum. Although the court cautioned that not every social media account operated by a public official is a government account, and that each case requires a fact-specific inquiry, it nevertheless concluded that the president had exercised official state action in blocking the critics from Twitter. To decide whether the superintendent and the assistant superintendent violated the parent's First Amendment right by blocking the parent on their Twitter accounts, the district court adopted the reasoning in the Second Circuit's decision on the Trump's Twitter case. First, the parent's attempted interaction with the superintendent and the assistant superintendent's Twitter accounts was protected by the First Amendment. Following someone on Twitter enables an individual to engage in a variety of expressive activity, including interacting with other followers about tweets and replying to and commenting on content. Second, the parents' allegations that these public officials operated their Twitter accounts in their official capacities support the inference that, at a minimum, these platforms are limited public forums, triggering some level of First Amendment protection. Third, the sequence of events supports the critical inference that the superintendent and the assistant superintendent removed the parent from these social media platforms as a result of her criticism of their policies and initiation of this lawsuit. The parent's critical Facebook comments was followed by deletion of those comments and being blocked from the school district's Facebook page and later being blocked from the superintendent's Twitter pages. The sequence of events can be used to prove that the school officials engaged in viewpoint discrimination. Finally, to decide whether school administrators operated their Twitter accounts in their official capacities, it is important to look at the origin and history of those accounts, including their registrations, the labels and markers associated with them, and the manner and frequency with which use them to conduct and promote school operations. Here, the parents' First Amendment interests as it relates to those Twitter accounts were relatively weak. Unlike the Facebook, the parent did not publish her views on Twitter. She never tweeted or commented at the two school administrators' Twitter pages. If that's the only information the school officials had in deciding to block someone on Twitter because that parent followed them on Twitter, then the First Amendment interest was weak. In this video, I discussed the school district's social media practices. We answered two questions here. Can a school district block its critics on the school district's official Facebook page? Can school administrators personally block critics on their own social media accounts? It is important to note here that the government has a strong interest in the ability to quickly remove unlawful speech from social media platforms. For example, if a government official received a death threat or other violent threat on social media, it is imperative that government officials have flexibility under the law to promptly remove such comments. My message to school administrators at the end of this video is that you cannot block critics on schools' official social media platform just because they criticize your policy. If you have a personal social media account and you put your official job title in your personal account profile and perform official duties on that personal account, you probably have transformed your personal social media platform to a public forum. If that's the case, you cannot block critics just because you don't like their viewpoints.